Good morning, everybody. First of all, I would like to thank the invitation to take part in this conference. It's a great honor to be here. Well, I was kindly asked to tell you about the recent organizational changes in the Portuguese judiciary and the impact they have on the judge position, namely on the basic principles of judicial independence and irremovability of judges. For this purpose, I will give you first a general overview on the latest judicial reform in Portugal, and then I will pay special attention to the new model of court management then introduced, and to the main issues it may raise in regard to the judge position. May I? May I? Okay. Well, until 2009, the management functions carried out within the Portuguese courts were confined to case management developed by the judge to whom each case was assigned in accordance with the applicable procedural law, but without any regard to the court as an organization. The court management tasks were centrally entrusted to the Ministry of Justice and to the Portuguese Judicial High Council, the CSM. The Ministry of Justice was and still is responsible for the justice budget, the non-just staff court, and the infrastructures, namely the premises and other equipment. The CSM is, according to the Portuguese Constitution and to the Statute of Judges, the self-governing body of the Portuguese judges. It is thus exclusively responsible for the appointment, transfer, promotion, evaluation, and discipline of judges. And until 2009, this activity, or its activity, was practically confined to these functions. In 2008, the Portuguese Parliament adopted a new law on the organization and functioning of judicial courts, which entered into force in 2009. This new regime was intended to be applied to all courts after a period of experimental application to 3 pilot courts, but it didn't last beyond the experimental period. In 2013, under the pressure of the economic and financial crisis, the Parliament adopted the law on the organization of the judicial system, which entered into force in September 2014, replacing the previous regimes. Notwithstanding some differences, the reform of 2014 follows up the reform began in 2008, maintaining its 3 pillars. First, the territorial enlargement of judicial circumscriptions. Second, the strengthening of specialization. And third, the implementation of a new model of management based on proximity and goal setting. Of course, the first pillar has an instrumental nature in relation to the others, for the enlargement of judicial circumscriptions facilitates specialization, more difficult to implement in small courts, and potentiates the adoption of more efficient managerial methods and tools. Both reforms enhance the scope of court management, having in view the improvement of quality through a better organization of the work, but without neglecting the case management, which pursues the same objective through an active and dynamic management of the process. Despite the pressure, the crisis, this reform is in line with the changes carried out in other European countries and even some American and Asian countries, where the failure of previous reforms based on the reinforcement of resources or law amendments made clear the need for new models of judicial management and organization. The new model of management introduced in Portugal in 2014 rests on 3 figures: the president of the court, the coordinator of the public prosecution office, and the judicial manager, to whom the law assigns specific powers, reserving some matters for joint decision within the management council. The judicial manager is appointed by the court president among 5 candidates previously selected by the Ministry of Justice. His powers respect mainly the management of the non-judge court staff, the buildings and other equipments, and the budget execution. He acts under the general guidelines of the court president, even when exercising his own powers, except in matters concerning the public prosecution office. The court president can dismiss the judicial manager anytime after hearing him. The coordinator of the public prosecution office is appointed by the respective High Council, and his powers concern mainly the public prosecution services. The court president is appointed by the Judicial High Council for 3 years mandate, with one possible renewal for 3 years more. He is chosen among judges from the first or the second instance, with no less than 15 years of seniority, classified with the highest score, very good, who attended specific training for the position. The choice of the candidates is done by secret vote in the plenary of the High Council. Among many others, the court president has the following powers or competencies: adopt or promote the adoption of measures to simplify and speed up procedures, reduce bureaucracy, improve the use of ICT, reinforce transparency, etc. Propose to the High Council the annual goals for the court. Monitor the performance of the court, namely the accomplishment of the established goals. Monitor the workflow of the court, identifying the cases pending for too long or not solved in reasonable time. And adopt or propose to the CSM, the High Council, the adoption of concrete management measures to improve the performance of the court, namely the prioritization of long-standing cases in order to reduce backlogs, the reassignment of judges to another post in the same court, or the assignment of cases to a different judge, having in view the balance of the workload and efficiency of the services. And the exercise of judicial functions in more than one post in the same court, considering the needs of the services and the existing workload. Well, however, many feared that this new model could lead to a submission of jurisdictional function to the managerial function and its values, namely efficiency and productivity. Therefore, at this point, one question naturally arises. Can this new model of management affect judicial independence and its corollaries, namely the irremovability of judges and the so-called principle of the natural judge? Well, I would say that as those principles are enshrined in the Portuguese constitution, the answer should be negative unless we find the law unconstitutional. Well, judicial independence is, in the first place, a guarantee of impartiality and consequently equality between citizens. But it is also a guarantee of non-subordination of justice to state reasons or to political or economic interests. Therefore, it must concern individual judges as well as the judiciary as a body, and it must be ensured both internally and externally. In its opinion number 1, concerning the independence of the judiciary, the Consultative Council of European Judges, and I quote, recognizes the judiciary as one of the 3 basic and equal pillars in the modern democratic state, points out that judicial independence is a prerequisite to the rule of law and a fundamental guarantee of a fair trial, and stresses that judicial independence is not a prerogative or a privilege in the own interests of judges, but in the interests of the rule of law and of those seeking and expecting justice. The irremovability of judges is a fundamental tool for the protection of judicial independence, being even considered an express element of this principle. As stated in the NCJ's report on minimum standards regarding evaluation of professional judges and the removability of members of the judiciary, and I quote, it is a fundamental consequence of judicial irremovability that tenure in a judicial office must be guaranteed until mandatory retirement age or the expiry of a fixed term of office. In addition, the principle of irremovability entails that a judge may not be transferred to a different post or switched to other functions without his consent. Nonetheless, there are acceptable exceptions to this general rule when a mandatory transfer of a judge to other duties, court or location has been ordered under specific circumstances as determined by law or otherwise established in a general abstract manner. And in the third place, the principle of the natural judge is also a fundamental tool for the protection of judicial independence, for it prevents the determination of an ad hoc competence of a certain judge or court to a certain cause. In other words, it prevents the choice of a concrete judge to a concrete case. Well, despite the criticisms that may be addressed to the new model of management introduced in 2014, the principle of judicial independence and its corollaries remain strongly protected. On the one hand, through the architecture of the Portuguese judiciary. on the other hand, by the limits or boundaries imposed by the Constitution and the Statute of Judges to court management activity, limits that really define that activity. Well, the main features, and very briefly, of that architecture are the following. The president of the court has to be a judge. The judicial manager, as I mentioned above, is appointed, acts under generic orientations, and can be dismissed by the court president. The decisions of the court president, as well as the decisions of the judicial manager, taken in the exercise of his own powers, may be challenged before the Judicial High Council. The executive power, including the MOJ, has no seat in the organ that manages the judiciary at the highest level, the CSM, that is composed by 70 members, the President of the Supreme Court, 7 judges elected by their peers, 2 members appointed by the President of the Republic, and 7 members elected by the Parliament, usually lawyers or law professors, not deputies. The decisions taken by the CSM can be appealed to a special chamber in the Supreme Court, and decisions of the Supreme Court can be appealed to the Constitutional Court on the ground of unconstitutionality of the law applied or of its interpretation. Let's now, and to conclude, see the most important boundaries of court management. Unlike other areas of the public sector, including the Public Prosecution Office, there is no hierarchical or functional subordination between judges and the President of the Court, and even the High Council. In fact, according to Article 4.1 of their statute, Portuguese judges are not subject to orders or instructions, except for the duty of lower courts to comply with the decisions handed down by the higher courts. Therefore, the court president leadership cannot be authoritative. It must be an inclusive and participated leadership exercised by a judge acting inter pares, who listens, respects, and considers all contributions and opinions. The powers of the court president are not means of the jurisdictional function. Therefore, they cannot invade the irreducible space of the judge, not only when he decides upon a case, but also in the conduct of the process. This is the main reason why the president of the court must be a judge. In this context, the intervention of the court president, namely when adopting measures to simplify and speed up procedures or reduce bureaucracy, necessarily assume an exogenous dimension. The court president is what we may call an organizational facilitator. Some of the new managerial measures mentioned above, like the reassignment of judges to another post, the assignment of cases to a different judge, or the exercise of the judicial functions in more than one post, don't affect in a direct manner the independence of the judge, but may affect his removability and the above-mentioned principle of the natural judge. This is precisely one of the most sensible points in the Portuguese reform. To prevent a breach on the principle of natural judge, the rules governing the assignment of cases, as well as the reassignment of judges, must be fixed in advance and in abstract terms in order to avoid the choice of a concrete judge to a concrete case. Furthermore, the violation of that principle may be the basis for the annulment of the decision by the higher court. In regard to the irremovability of judges, the initial version of the law on the organization of the judicial system didn't provide for the consent of the judge for his reassignment to another post or for the exercise of judicial functions in more than one post. However, it was amended in 2016 to require the judge's agreement for his reassignment to a different post. But the law remains silent regarding the agreement to the exercise of judicial functions in more than one post. However, pursuant to Article 6 of the statute, Portuguese judges are appointed for life and cannot be transferred, suspended, even promoted, retired, dismissed, or in any way see their position changed, except in the situations foreseen in the statute. Therefore, it is at least doubtful that a judge's agreement is not required for the exercise of judicial functions in more than one post. But even if we consider this agreement as not necessary, the principle of irremovability renders it imperative that the grounds for this measure be clearly established in a general and abstract manner. Well, to conclude, I would say that Portuguese judges remain highly independent, but this doesn't mean we are exempt from the necessary efforts to ensure a truly independent judicial activity. Individual judges, court presidents and especially high councils, as well as the judges' associations, must act as bastions of judicial independence. Thank you very much for your attention.